fourth simple step is implement your estate plan. And you might say, what do you mean implement your estate plan? I hire a lawyer, you prepared a plan, I understand it, I signed it, I'm done, right? No, you are not done yet, because there are many assets that are not governed by your will or by your trust, your revocable living trust. So think about your 401k or your IRA or your life insurance policy. If you think about those, and those could be very large assets, they can make up a big part of your estate. They will pay on death according to who you put down on the beneficiary designation. The beneficiary designation says where the asset goes upon your death. So you need to make sure your beneficiary designation is correct. The lawyer typically does not do that. Your will does not govern that. So let's say you are a couple and you agree that you want to protect assets for each other on the first death. And so your will creates this asset protection supplemental needs trust. And one of your biggest assets is your IRA or your 401k. You'll need to change your beneficiary designation. The current one probably says it pays outright to my spouse. You don't want it to pay outright to the spouse. You want that asset to pay to the supplemental needs trust created by your will. You have to make that change. If you don't make that change, nothing has changed, and the asset won't pay to the trust. Instead, it will pay outright to the spouse. So that's just one example of what do you need to do to implement your estate plan. A lot of people think that the will covers everything. It does not. It only covers what we call probate assets. An IRA or 401k is not a probate asset. How about bank accounts? You might have bank accounts and they can either be probate or non-probate. If they're probate assets, you're the owner of them. And it doesn't say where it goes on your death. That's a probate asset. It goes under your will. What if instead you said, I want this bank account to pay not like what I said under my will, but I want it to go to my favored child? Then you'll do a pay on death designation, says it pays on my death to my child. Or what if you have, you're a couple again, and maybe the two of you just thought, oh, it'd be a good idea to put, one of our kids on our bank account. And it's going to be held joint tenants with right of survivorship. What that means is the last person who is standing, the last person to survive, gets the entire account. And you might have done this for convenience purposes so that your child could write checks, which is not the way to give authority to your kid to write checks. Durable power of attorney and going to the bank is. If you put your kid on the bank account, joint tenant with right of survivorship, they get the bank account when you die. And you might not have intended that. You might have wanted to go to your equally among your kids, but you didn't set it up that way. And now you're relying on your child, who's the owner, joint owner of the account on your death, to divide it with their siblings, which they may or may not do. And if they don't do it, and the siblings want to force the issue, then it gets into litigation. Anytime you hear the word litigation, think money. There's going to be money paid out for legal fees. So implementing your estate plan is making sure those assets that pay by way of beneficiary designation are correctly set up, that you don't hold as joint owners certain assets that shouldn't be jointly held, that should go under your will. Other things to implement your plan is to make sure you have all these great new estate planning documents. What are you supposed to do with them? Number one, you keep them in a safe place. Number two, you distribute them to the appropriate people. Your durable power for healthcare should be given to your healthcare agent, and a copy should go to your primary physician. Your durable power of attorney for finances should go to the person that you've designated under that durable power of attorney to make financial decisions for you. You should take a copy of that and provide it to your bank and to wherever you hold investments. And I tell clients, typically the bank or the financial company will go, oh, that's nice. Hey, we've got our own form. Would you sign our own form? Because that makes the bank happy. It's like, go ahead, sign their own form. It does not invalidate the general durable power of attorney to be prepared for you. It just makes the bank happy, or the financial institution. It makes things easier. One of the reasons that you do an estate plan is to make things easier, not just for yourself, but for others if they have to act on your behalf should you lose capacity. And that's what we're talking about. So have everything in a safe location. Tell your personal representative, your executor, where your original will is, where your original documents are. Should you provide the will to that person? It really depends on your situation. I typically tell clients that they don't have to provide the will. That might be something that they want to hold back. Maybe they want to change the will in the future. So you might not want to provide the will. Typically, we don't recommend that you file the will with the county for those same reasons. You might want to change the will at some point in time. Sometimes people are concerned that somebody might take and tear up their will and try to change their estate plan. So there are ways that you can safeguard your will. Safe deposit box, talk with your attorney about safeguarding your will. Other things about implementing your estate plan besides the legal documents is try to make sense of all your important paperwork. Have things in a sensible location. Where is your IRA? Where is your life insurance? Where's these bank statements? If you're looking at what all your assets are, try to put this in some logical place that your decision maker can find them if you're not there to guide them. Make their life easier. That definitely includes making sure that your family or whomever is going to be taking care of things after you're gone. Know what your wishes are with regard to burial or cremation or prepaid plans, that sort of thing. Sometimes people go, well, shouldn't I put it in my will? It's like, no, the will is too late. Nobody's going to be looking at your will the moment you die. You want to have it in advance, put somewhere, hey, this is where all my important papers are. They also include what my wishes are with regard to my remains, and that I prepaid for the plan or I haven't, but this is what I would like. And if you really want to go that extra step, help them with your obituary, family members. What's important to you? I know I'm going way over the top here with this planning, but those are the types of things that you can do to help out those people when you're gone. So that fourth step, implementing the plan, is probably the most overlooked step, and it's one of the most important steps, at least in terms of that gift that you're giving to your family to make things easier for them when you're gone.